Good day, Crime Talk aficionados. We have a great show for you today. First, a theory for a motive in the case of Bryan Kohberger is debunked as quickly as it was released. More information on the sheriff who shot the judge. Jury selection begins in the case of Sean Combs. Lori Vallow, well, she wants a new trial for juror misconduct. We have a Karen Reed update. A monster learns his fate in Pennsylvania. This day in legal history, and our dumb criminal of the day. Let's talk about it.
Lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. Now, before we get started, let me remind you to go to crimetalksearch.com, sign up for that background subscription service today. When you do, you'll be able to do a background search on as many people in the United States as you desire. So whether you want to search one person or everybody in the neighborhood or everybody involved in a high-profile case, guess what? You can do it when you go to crimetalksearch.com. You're going to get phone numbers. You're going to get emails. You're going to get social media presence. You're going to find out if they own property. Are there liens? Are there judgments? Is there criminal history? Are they divorced? Are they married? Do they have to register on one of those sex offender registries? Yes, everything you want to know about somebody. And I'm telling you, we use this almost daily in our law firm doing a background search. It searches so much information. Sometimes we're surprised that we get information that doesn't even show up on official government background searches that we get from the district attorney's office. It's good stuff. Go to crimetalksearch.com and sign up today. All right, let's go ahead and open the record for May 6th of 2025. And first, let's start out with the Bryan Kohberger matter. All right. Yes, a theory was put out there by a journalist, a guy by the name of Howard Blum. And guess what? It was debunked as quickly as it was put out. And this is why you sometimes have to wait for information to come out from the courts. People can speculate all day long, but guess what? It just doesn't matter. Okay? And I've said this before, and I will say it again. It doesn't matter what you think. It doesn't matter what you believe in your heart of heart, in your gut, your instincts. It only matters what you can prove. That's it, ladies and gentlemen. Legal and competent evidence in a court of law. And then when you actually talk to the people that are supposedly involved in this crazy theory and it's completely debunked, well, you just look silly. All right. So like I said, this Howard Blum guy claims prosecutors may argue Bryan Kohberger committed the murders to impress his former professor, renowned forensic psychologist, Dr. Catherine Ramsland. Now, according to Blum's article, Kohberger wanted to prove his intelligence by executing the perfect crime. It even suggests that the two stayed in contact after the murders. Ramsland has since responded to those claims with a careful, not quite. A renowned forensic psychologist has challenged these claims made in this article, saying that prosecutors believe Kohberger committed the University of Idaho quadruple killings to impress her. Now, Howard Blum, in his article published in an online newsletter called Airmail, wrote that Kohberger, charged with killing 4 University of Idaho students in November of 2022, committed the crimes to impress Catherine Ramsland, his former forensic psychology professor at DeSalle University in Pennsylvania. Now, according to Blum's article, prosecutors are preparing to argue that the pupil was ready to become the teacher. He'd kill and get away with it. He'd prove how smart he was. He would show how much he'd learned. However, in a statement by Ramsland, she categorically denied these claims in the article, stating that she had no email correspondence with Bryan Kohberger while he was at the Washington State University working on his PhD, and has not been in contact with him since his arrest. She said, quote, "I called his parents as a gesture of kindness, but I do not advise them about the case," Ramsland said, "and I did not call them hours after the arrest as Blum claims," end quote. Ramsland also refuted other claims in the article, including that she had discussed a book with Kohberger's sister or that she had brokered anything regarding legal representation. Now, in response to Ramblin's denial, Blum acknowledged the errors regarding the email correspondence, but defended his overall theory as a hypothesis. I mean, that's an editorial. That's not news, ladies and gentlemen. That is an editorial masquerading as a news article. It's garbage. And yet here we are talking about the garbage, right? Because it's ridiculous. Anyway, like I said, it doesn't matter what you think. You can put it out there to get clicks and all that kind of stuff, but you're going to look silly when somebody actually goes to the person. You would think that this reporter was going to do it, was going to come out with this breaking news and say, I spoke with this individual, which he never had, and he runs with it. And then he says, well, it's a theory and a hypothesis. I got a theory for you, Mr. Blum. Does anybody really ever need a theory to kill, a motive to go kill somebody? I've done criminal defense for 30 years. And I'm telling you, most of the time, unless it's like a DV thing or a gang retaliation thing, I have seen cases where, in fact, I got one right now. It was just for the sport of it. Literally for the sport of it. The thrill of it, ladies and gentlemen. That's all somebody needs. I don't know if Bryan Kohberger was trying to impress anybody other than himself. I mean, he's denied it, so we'll give him the presumption of innocence. He says it is not him. We're going to have to wait until the prosecution presents legal and competent evidence admissible in court, subject to cross-examination, to see where ultimately this winds up. Who knows? The prosecution could get up there and just mess this whole thing up. You never know. Maybe they couldn't reach their burden of proof. But I mean, seriously, and I get people that send me some crazy stuff about theories, and I respond to them and I say, that's interesting, but how do you prove it? How do you prove it? Like I said, it only matters what you can prove. And when the professor herself says, I haven't spoken with the guy since he left school, since he was a student in Washington State, but yet this guy's saying he's out there trying to impress her. Where does he get this stuff? Back it up with real evidence, ladies and gentlemen, not theories and hypotheses. Seriously, ladies and gentlemen. Next, let's talk about the sheriff who shot the judge. New surveillance footage captured the moments that led a Kentucky sheriff to shoot his longtime friend and local judge, Ken Mullins, in his chambers. Now, the alleged murder unfolded September 19th, 2024, when the Letcher County Sheriff, Sean Mickey Steins, was seen in a footage entering Mullins' office as he sat with several others in the judge's chambers. Now, Steins and Mullin had been out for lunch together with several other people in Mullins' office shortly before the shooting, and the sheriff appears to order the others out of the room at the start of the footage. Now, the video shows Stein confronting Mullins as soon as he enters the room, sitting across from him and the desk and bringing something up on his phone. At one point, Mullins hands his phone across the desk to Steins before the sheriff takes the phone and attempts to make a call that doesn't appear to have been answered. Steins then briefly looked through the phone before tossing it back on the desk, with Mullins still appearing to try and calmly talk the sheriff down from a rage. The footage then shows Steins stand up and lift up his shirt to reveal his gun holster on his hip, which caused the judge to then take notice and lift his hands up. Prosecutors have obviously charged Steins with first-degree murder. However, his attorneys indicated they are preparing to mount an insanity defense in the upcoming trial. The footage offers the clearest look yet at the shooting last year that obviously shocked the small town of Whitesburg, Kentucky, where the two men played important roles in their community. Now, they were known as longtime friends and often ate lunch together, including on the day that Mullins was killed. Now, their familiarity was evident in the footage from inside Mullins' chambers as the judge sat smoking a cigarette with his legs crossed as Steins grilled him. Although the footage was released without sound, you can tell from the video that the sheriff was ready to go the minute he walked in. By contrast, Mullins is very nonchalant, very carefree. He's smoking a cigarette and didn't appear to understand what the imminent danger he was in. At one point, it looks like Mullins is shrugging everything off, and it created a little more angst towards the judge because he wasn't taking it seriously, whatever was being spoken about, and he kind of playing off as it wasn't kind of a big deal from the video. Now, the judge is kind of going, "What are you doing? Put the gun down," using his hands gestures, kind of flinging him out like, "What are you doing?" In a sudden move, the judge then puts his hands up by his head in an apparent reaction to something the sheriff said. The footage ends as Stein allegedly shot Mullins as he sat in his desk chair. Now, the motive behind the shooting remains unclear. However, Stein's attorney indicated in court filings in March that they intend to launch an insanity defense. Defense attorney Jeremy Bartley filed a motion saying his client's state of mind at the time of the shooting would be key to the upcoming trial. He said the case will hinge on testimony that Steins gave at a deposition days before the September 2024 shooting. At the deposition, the sheriff had to answer questions about one of the deputies allegedly sexually assaulting jail inmates. An accuser in that case claimed that she was forced by a deputy sheriff to have sex in Mullins' chambers for 6 months in exchange for staying out of jail. Now, Bartley said Steins feared that backlash from his deposition testimony caused him to fear that his or her family's lives were in danger. The attorney said Steins' mental health was affected by that perceived threat. Ultimately, he was in fear for the safety of his wife and his daughter, and I think you will see there is a result of that, the defense attorney noted. Bartley added that although Steins tried to call his daughter from Mullins' phone, their phone exchange had nothing to do with any relationship between the judge and the sheriff's daughter. He added that Steins received a call from his aunt during his interaction with Judge Mullins in his chambers, which was one of the times that he brought out the phone from his pocket. As the attorney also denied rumors of any kind of relationship between Mullins and Stein's daughter. The attorney noted, and he said his client was experiencing increased paranoia over the safety of his family at the time, particularly due to the deposition he had just given. Specifically, in the approximate 2-week period prior to the incident in the judge's chambers, pretty much all the witnesses, the investigators talked to support what those close to Mickey had said as well, according to his attorney. And that's simply this. Mickey had become extremely paranoid. He'd become sleepless, basically wasn't sleeping. He slept little, if at all. He had become withdrawn. The attorney said, as you know, it was of such a concern that his coworkers had actually urged him to go to the doctor, and ultimately the day prior to the shooting. Little breaking news there, I guess. Nothing as it relates to a relationship with the judge and the sheriff's daughter, which is obviously a good thing. Going to be tough to do a mental health defense unless you can say that he is actually suffering from some sort of mental disease or defect. Good luck with that, Sheriff Steins, or former Sheriff Steins to be more accurate. You can raise the defense, but I don't think it's going to prevail on this one. Next, in the case of Sean P. Did he do it? Combs. That's right. Jury selection in the federal criminal case against Sean Combs continued this morning as the judge and attorneys worked to whittle down the pool of 12 jurors and 6 alternates. The two sides will question the potential jurors in the selection process, and it is expected that it'll go through the week. Now, this process, as we've talked about many times, is known as voir dire. It is a French term that means to speak the truth, to make sure that you can find jurors that are impartial, and you have to speak the truth about any biases that you may have towards either the prosecution or the defense, so that each side believes that they are going to find a juror and everybody's going to say, we get a fair shake, right? It's simply not fair for either side if somebody has a bias or grudge towards either the prosecution or the defense. So obviously, if there are challenges for cause, the judge will decide whether they will be approved or not. Now, the judge did speak to the jury pool of potential jurors Monday morning, thanking them for their service, and said that the trial could take up to 8 weeks. And she said, hey, let's be serious. You all are inconvenienced by this service. However, it is an honor and a privilege of the jury to be involved in this particular judicial process. I totally believe that. Jury duty is one of the highest callings. And other than maybe voting, this is where people's constitutional rights, where the rubber really hits the road. Anyway, the judge reviewed answers to their questionnaires, asking their views on sexual violence, sex trafficking, guns, and illicit drugs. I think most people would say, and the jurors will be told by the attorneys, that this is not a referendum on whether sexual violence or sex trafficking is good or bad. It's something that the jury has to decide whether it happened or not. I think all people would say sexual violence, sex trafficking, bad. Illicit drugs, bad, right? But the question is, did the events take place as the prosecution alleged that actually made it a crime? Now, some potential jurors were asked to identify certain celebrities, and others were asked about possible media influence in the trial. Now, the defense attorneys objected to a potential juror who worked as a photo producer for HBO due to the company that he works for coming out with the Fall of Diddy documentary. Anyway, the judge allowed the juror to remain in the jury pool, but allowed for more questioning later in the process of that juror as to any potential bias there. One potential juror was dismissed as they referred to the hotel surveillance tape of Combs attacking his ex-girlfriend, singer Cassie Ventura, in Los Angeles at a hotel as, quote, damning. I think that's enough for cause. See ya. Anyway, Combs faces federal charges for racketeering, conspiracy, sexual trafficking by force, fraud, and coercion, and transportation to engage in prostitution. Now, the music producer has been held without bail since September of 2024 when he was arrested, which came after two of his homes were raided by federal investigators some 7 months earlier. Prosecutors have alleged that Combs used the resources of his music empire to create a criminal enterprise whose members and associates engaged in and attempted to engage in, among other crimes, sex trafficking, forced labor, kidnapping, arson, bribery, and obstruction of justice. Now, Sean Combs has denied all the allegations. And, like I said, jury selection is supposed to take throughout the most of this week. Opening statements are scheduled for May 12th. Obviously, that's contingent upon whether they get a jury seated. Next, Lori Vallow wants a new trial, saying there was juror misconduct. Now, Lori Vallow has requested a new trial in Arizona for several reasons, including juror misconduct, a discovery violation, and prosecutorial misconduct. Now, Lori Vallow, who represented herself at trial, filed the motion pro se with the help of her paralegal that was approved by the court. Now, she is expected back in court on May 14th for a status conference ahead of her next trial in Arizona on charges that she conspired to murder her niece's ex-husband, Brandon Boudreaux, back in October of 2019. That trial is expected to begin at the end of the month. Now, Lori Vallow is 0 for 2 when it comes to trial, and by all accounts, she is responsible for at least 4 dead bodies at this point, right? JJ, Ty Lee, her children, Tammy Vallow, her fifth husband's now deceased wife, and then, of course, the case in Arizona with Charles Vallow. She is stacking the bodies up, to say the least. Well, last month, Vallow was convicted of conspiring to kill her fourth husband, Charles Vallow. That conviction followed several other convictions in Idaho, like I said, where she was sentenced to multiple life sentences. Well, as it relates to the allegations in the motion for a new trial, Vallow says that Juror 15 in her Arizona trial knew about the Idaho case, which amounts to juror misconduct. Now, Ms. Vallow never testified in her Arizona trial, which meant that her prior convictions and the death of her children were never introduced in evidence, basically on cross-examination, because that would go to her character. The juror can consider that information as it relates to her credibility as a juror. Anyway, so following the verdict, Juror 15 did an interview with the media in which he said, quote, I feel sorry for her driving home yesterday. I was like, God, she's spending the next 3 lives in prison in a cell. Now, because Daybell never testified at trial, like I said, she argues in her motion that the juror should not have known about about her previous conviction. Juror 15 noted in the same interview that he had been inclined to find Daybell not guilty until the day of the closing arguments. The motion also accuses the prosecution of misconduct by eliciting irrelevant, prejudicial, and improper character evidence at trial, including editing portions of her police interview to eliminate moments where she showed emotion. Now, in her motion, Daybell also accuses the judge of bias in its rulings both before trial and during the trial itself. No. Okay. Denied. All right. This juror 15, it doesn't say when he learned about this new information. It could have been afterwards. I believe that's actually what took place when I saw this originally come out. But just because you know of somebody's past conduct, it doesn't mean that it should prejudice you. In fact, he said he was leaning towards not guilty until the prosecutor kind of wrapped it up and put it all together for the jury in closing arguments. That's what closing arguments are for. So I think that will be denied, and it'll more than likely be denied without a hearing. I believe the judge could say, let's bring in juror 15 and say if he was prejudiced in any way, but did it affect regardless of whatever he knew, did that affect his ability to be fair and impartial? I'm sure the juror will say, no, it did not. So I think that will be denied. Prosecutorial misconduct, a lot of those motions were already raised, denied, and saying that the judge was biased against her, denied. Lori Vallow, nice try. I get it. You're doing what you think you need to do, just like a lawyer would do if they thought there was an issue there. But those are appellate issues. You're not going to get a new trial from the trial judge saying, you know what, you're right. I was wrong. You received an unfair trial. Let's do this again. He's not going to do that. Denied on all of those issues. Next, a Karen Reed update. So witness testimony continues today for the 10th day in the Karen Reed trial as the former Canton police lieutenant concluded cross-examination about evidence collected on the day that John O'Keefe died. A meteorologist is also on the stand testifying about weather conditions the night that O'Keefe died as well. Now, retired Canton police lieutenant Paul Gallagher was on the stand for cross-examination when the court ended the day on Monday. He started Tuesday back on the stand facing questioning from defense attorney Alan Jackson and finished his testimony about 90 minutes later. Now, Special Prosecutor Brennan has been handling the majority of the direct questioning throughout the trial. We also heard from meteorologist Robert Gilman, who took the stand late Tuesday morning. Adam Lally, who was the lead prosecutor for the first trial, handled that questioning. Now, Gilman testified about the conditions in Canton on January 29th of 2022. And according to Canton, there was about 3.9 inches of snow accumulated by 6 a.m. By 7 a.m., snow began falling moderately at about 1.5 inches per hour. By the end of the day, about 23.8 inches of snow had fallen in Canton. It was apparently one of the biggest snowstorms in January in the history, according to the witness. Now, before the morning recess, Brennan played 2 clips of Reed speaking in media interviews. The defense asked to have a sidebar, and the clips were not played until after a second sidebar following the morning break. In one clip from a recent HBO documentary, Reed described O'Keefe holding a cocktail glass. So, when John got out of the car at Brian Albert's house, he took my full vodka soda, which was in the cup holder, Reed said in the clip. A day earlier, Gallagher held up a broken cocktail glass that he said he discovered in the area where O'Keefe's body was found. In the second clip from the same documentary, Reed described why, in a previous interview, she said she remembered thinking, could I have hit him? Did I hit him? Quote, I said, yeah. My first thought was I had been out late, I had been drinking, and he's in the general vicinity of when I last saw him, Reed said. So he's in the front yard to the house near the front door, and no one's coming out of the house. Jen McCabe is telling that nobody's seen him. So I'm thinking, Jesus, was I starting to pull away and I ran over his foot? He roughly was where I left him. So yeah, when I found him, I was thinking, did I clip him somehow? End quote. Throughout the trial, Brennan has been playing clips from various interviews attempting to use Reed's own words against her. And because the defense attorneys do not dispute the clips are authentic, no witness has to be on the stand when the clips are played. Defense attorneys has objected to some of the clips, but the judge has allowed each of them to be played thus far. Ladies and gentlemen, I told you from the beginning, this Brennan guy is good, and it is legal malpractice for Jackson to have allowed Karen Reed to do these interviews. Absolutely. I mean, the client can do what he wants, but I'm sure he's got it papered somewhere saying, don't do this. This could be bad. It could come back to bite you, because anything you say as a defendant can and will be used against you. And how many times have we said this, ladies and gentlemen? It's always the defendant's own words that come back and bite them in the ass. And here you have repeatedly Karen Reed saying, I hit him. I may have hit him. Well, he did have this glass, and coincidentally, they have the little glass that they recovered near his body. And then you have the other one saying he never made it in. It shows, ladies and gentlemen, when you're a criminal defendant accused of a crime, you keep your mouth shut. The only person that you can talk to is your defense team, and what you say is absolutely confidential unless they have permission to release that information. And like I said, I'm sure it was all Karen Reed's doing. We've got to get the good publicity, but she makes admissions, ladies and gentlemen. She slow walks it. Well, maybe I clipped his foot. Maybe I did that, but I couldn't have killed him, right? She's admitting to it. And Mr. Brennan told you he's good. I told you he's good. And I also told you the defense never does well in the second trial, because here in this particular case, Brennan has dismantled the defense of Karen Reed. I guarantee you they're going to get up and try to argue this cop killed cop theory. I don't think it's going to fly. And if you've been watching this trial, I think the defense has not been as effective as they were the first time. The first trial, the prosecution wasn't prepared. You had, frankly, prosecutors that aren't as good as Brennan there, and it showed. And, you know, we'll have to wait and see what happens. You never know what a jury will do. But I think at this point, if you're keeping score, so to speak, at home, prosecution is winning on this one. Gallagher, now jumping back to the witnesses, Gallagher said the reason Canton police didn't take pictures of the car is that's because the Massachusetts State Police took over the investigation when O'Keefe died. This is important to know. Now, unfortunately, John O'Keefe was deceased at the time. And once John O'Keefe becomes deceased, it becomes the state police investigation. The Norfolk County District Attorney did the investigation, and that's why it is not our investigation. It is up to the investigating agency to make those decisions, Gallagher said when asked why the SUV wasn't photographed on January 29th, 30th, or 31st. Now, Jackson shows photographs of the SUV in the police garage, including an investigator holding open a brown paper bag with a plastic Solo cup inside. Police said the cup had blood in them, and that had been collected near the scene the morning O'Keefe's body was found. The defense attorney noted that the cups were not sealed. They were not in evidence bags. They were in a grocery bag, correct? Jackson said. Gallagher had previously testified that the blood had been frozen in the snow. It was put into the cups, then into a brown paper grocery bag, which frankly, ladies and gentlemen, is quite normal and routine in collection of evidence. It really is. Jackson attempted to show that there could have been cross-contamination with the evidence and it was displayed near the SUV. You will agree that having unsealed and unsecured blood right next to the rear of the SUV is a recipe for cross-contamination, wouldn't you? Jackson asked. Not in the hands of a trained criminalist, Gallagher replied. On redirect questioning, Mr. Brennan asked Gallagher if he saw anything suspicious from the state investigators when they were handling evidence near Reed's car. Did you see anything during that time that caused you any concern about the potential corruption of evidence? Brennan asked. No, I had complete faith in the criminalist, Gallagher responded. Anyway, the Canton Police Deputy Chief Thomas Keller is a neighbor who lives across the street from Bryan Albert. He had an Arlo camera system set up in his front yard. And Gallagher said that he did not ask Keller for the footage from the camera from the time the police believe Reed hit O'Keefe with her SUV. Under cross-examination from Jackson, Gallagher said the reason he did not ask for the footage is that he had picked up packages at the Keller home in the past and knew that the camera would not have captured the incident. According to Gallagher, the camera was pointed at the front porch and part of the front lawn. To me, there was no expectation that it had captured anything, so I didn't think it was practical, Gallagher said. Now, Brian Higgins, Jackson began questioning of Gallagher about his relationship with the Bureau of Alcohol, Tobacco, and Firearms and Explosive Agents, Brian Higgins. It was revealed during the first trial that Higgins exchanged flirty texts with Reed. Defense attorneys argue that Higgins, who was out drinking with Reed and O'Keefe on the night in question, is one of the men who could have killed O'Keefe during his a fight inside the home. Now, Gallagher confirmed that Higgins had a key card that allowed him access to parts of the Canton Police Department. And Gallagher also confirmed that he was friends with Higgins and would have recused himself from interviewing him if the opportunity had even come up. Now, after Brennan questioned Gallagher on redirect, Jackson returned for another round of cross-examination. He attempted to show that Gallagher did not know that Higgins was in the home the night O'Keefe died, despite returning to question people from 34 Fairview Road hours after the body was discovered. Gallagher said he later discovered Higgins was one of the people in the home when he read it from colleagues' written police reports. It was a very fast-moving scene and pace, Gallagher said. Jackson also asked why police did not search Brian Albert's home. Gallagher said there was not probable cause, and there was not been any evidence that O'Keefe had actually been inside the home the night that he died. As cross-examination resumed on Tuesday, Jackson asked Gallagher about clearing snow in the lawn with a leaf blower. You didn't see a single piece of bright red plastic taillight material, did you? Jackson asked. Gallagher said no. As a matter of fact, you didn't see 46 pieces of taillight material, either clear or bright red plastic, in any of the areas that you searched. Jackson followed up. Gallagher said he did not. In the past, defense attorneys have said that the pieces of taillights found at the scene in the days after O'Keefe's death were planted by the police. Anyway, Gallagher testified Monday about using a leaf blower to clear the top layer of snow in the area where O'Keefe's body was found in an effort to uncover evidence. Gallagher said that he had found a broken cocktail glass while searching the scene. He also told jurors, remember the cocktail glass that Karen Reed said in the interview that that O'Keefe got out of the car holding? He also told jurors that police collected coagulated blood in the snow and put the samples into a red plastic Solo cup. Also on Monday, several people who were at 34 Fairview Road the night of O'Keefe died took the stand and did an EMT who said that she heard Reed say, "I hit him," when fire responders arrived on the scene. Prosecutors tried to show that the EMT has connections to Brian Albert's daughter. I don't know. Everybody is in this big conspiracy, according to the defense. Don't get me wrong. I've run conspiracy defenses. They're tough to prove, ladies and gentlemen, because everybody has to be involved. And at a certain point, it becomes a little tenuous that everybody's involved and that they're willing to perjure themselves for all those things. They're very tough, ladies and gentlemen. When you say the cops are the evil cops. Now, don't get me wrong. There are bad cops out there. I've seen it, but the truth usually comes out. But they're very tough to prove when you try to say there's a grand conspiracy to frame your client. Anyway, Miss Reed has pled not guilty to the charges of second-degree murder, manslaughter, while operating under the influence of alcohol and leaving the scene of personal injury or death. Obviously, she's given the presumption of innocence, and we are going to find out all at the same time whether she did it or not. Next, a monster is sentenced in Pennsylvania. The Pennsylvania man who killed a mother of four Uber driver has been sentenced to life behind bars without parole for the brutal murder. Now, Calvin Crew, who is 25, was sentenced on Monday to life without the possibility of parole for the 2022 slaying of Christina Kuza. Now, the dash cam video footage showed the 38-year-old mother of four begging for her life when Crew put a gun to her head after she picked him up for a ride. Crew was convicted of first-degree murder in February and faced the death penalty. However, Spikuza's family asked that he be spared and that the murderer be sentenced to life with an additional 13 to 26 years for the kidnapping and robbery charges. "You should have the death penalty. We showed you mercy," said Spikuza's mother, Cindy Spikuza. "You executed her. No mercy, no remorse. It was abhorrent. It was murder," end quote. Now, Crew was not in court for sentencing at his own request, and his defense attorney said his client maintained his innocence and plans to appeal. I don't know why judges do that. Allow a defendant not to be present. He should be present. It is a critical stage of the proceedings. He has a mandatory right to make a statement in allocution, and I'm sure he will say that it was error for not making him show up for court when they filed the notice of appeal. And frankly, be a man. You've been convicted, so as a matter of law and as a matter of fact, you're guilty. And if you say you're innocent, then show up to court and profess your innocence. When you don't show up, you look like a coward. Well, that's what some of the family members said too. No reason other than a coward who couldn't be here today to face this, said Pacuzzi's life partner, Brandon Marto. Police and crew used his girlfriend's phone to order the Uber back in February of 2022, then held a gun at Pacuzzi's head and told her to keep driving. She reached back 4 seconds after the gun was raised to her head, and when she felt the weapon, and incredulously said, "You've got to be joking," according to the video. Now, crew told her again to keep driving, and she told him that she has a family. "I'm begging you, I have 4 kids. I got a family too," crew retorted. "Now drive." Repeatedly, he told her to complete the trip. She asked him multiple times to put the gun down, but he kept it pointed to the back of her neck. "Please take the gun off me," she said. He reached up into the front seat and grabbed her phone from the dashboard. "Do what I say and everything will be all right," he told her. The video cuts after crew grabs Pacuzzi's dash cam and turns it off. It is unclear what happened next, although the ride ended with the driver's brutal murder. During the drive, according to the court filings, Crew's girlfriend sent him a message saying, "I'm not going to jail if we get caught." Pacuzzi was found dead with a single gunshot wound to the back of her head and a 9mm shell casing near her body in a wooded area there in Pennsylvania. Ultimately, Pacuzzi's dashboard camera was recovered 1/10 of a mile from the spot where she was picked up. Crew and police viewed the footage from the mini SD card in the camera, which recorded audio and video from the front and back of the car. Crew is a convicted felon and was not allowed to possess a firearm. Days before the homicide warrant was filed, he was arrested by the Northern Regional Police Department for a felony related to the sale and transfer of firearms and a misdemeanor falsification to authorities. So basically, he was trying to sell a gun to a pawn shop to that effect. Horrific. I mean, I've represented lots of defendants. I get that. But here is the gist of it. That's just pure evil. What was his motive, I guess, right? To think he's going to have no witnesses for the sport of it? Who knows? Doesn't really matter. But he's been found guilty. Mr. Crew's been found guilty. And when you're found guilty by a jury, as a matter of law and as a matter of fact, he is guilty of all the crimes charged. Next, this day in legal history, on May 6th, 1861, Arkansas secedes from the Union, raises legal questions about the state sovereignty and federal authority at the onset of the Civil War. On May 6, 1906, the Pure Food and Drug Act's debates intensifies, later establishing the FDA and regulations against misbranded products, a consumer protection milestone. And on this day in 1919, the Volstead Act's enforcement plans are drafted, setting the stage for prohibition and subsequent organized crime law enforcement because organized crime was surging. And on this day in 1960, the Civil Rights Act of 1960, voter protection measures, faces legal tests, strengthening federal oversight of discriminatory election practices. And on this day, May 6, 1994, Paula Jones files a lawsuit against President Bill Clinton for sexual harassment, sparking legal debates over presidential immunity. And finally today, our dumb criminal of the day. The devil made me do it. That's what a 73-year-old woman told the police in Florida when she was arrested for shoplifting merchandise at a Walmart. Police allege that Angela Velasquez Tabordo was stopped by the Walmart security when she sought to exit the Tampa area store with $121.85 worth of merchandise, which included shampoo, socks, men's shorts. Now, Tabora police say, had stashed the items in a plastic bag that she brought into the store. Now, according to investigators, Tabora originally denied swiping the merchandise, but later admitted they did attempt to leave the store without paying for the items. As for her motive for the alleged larceny, police said that Tabora stated the devil told them to buy them for somebody else. She didn't have enough money, so she attempted to leave with them. The arrest affidavit does not further describe the defendant's conversations with the devil, who is not charged in relation to this, because otherwise that'd be a potential conspiracy, would it not? Anyway, Tabora was released from the jail the morning after, posting a $150 bond, coincidentally just about the same amount of the cost of the merchandise that she stole. Miss Tabora was ordered by the judge to stay away from Walmart, but she's not barred from contact with any mythical personifications of evil, because we don't want any more conspiracies going on with the devil. Miss Tabora, you are our dumb criminal of the day. Congratulations. You made it. You know, just paying for that merchandise would have been a lot less of a hassle. And since you had the $150 to post the bond, you had the money to do it. I guess that would be an untruth that you maybe told the police officers now, wouldn't it? All right, that's all we have for today, ladies and gentlemen. Thanks for watching. We'll see you next time. And remember, the Constitution matters.